Before we get officially started with just one moment of class business, Professor Reppy and I had a phone call today from PETA, and they are looking for a student to work on a project this summer, a volunteer project. If you're going to be in DC, the Bay Area, LA, it would be a perfect opportunity, or if you're in Norfolk, which is where they're based.
And New York.
And New York City, because they have offices there. But there will be an opportunity to work on, we talked about the Happy Cow ads that are run in California. In fact, Bruce Wagman has dealt with this issue, and it's an opportunity to work on a project challenging those false and deceptive ads. We've got a brief description here of the project. If you have interest in working on this, even if you have another project, I don't know if I would recommend it if you're taking the bar, but there's a summary of it here if you're interested. So without further ado, I look forward to you getting to know Bruce Wagman. We are really honored to have one of the country's foremost advocates for animals with us today. He is a partner at Schiff Hardin in San Francisco. He teaches at Bolt, Hastings, and Stanford. He's technically teaching here since he's also the author of the textbook we're using now in its third edition. He has successfully litigated all over the country and in North Carolina. The Woodley case, which we'll hear some about today, I'm sure, one of the largest abuse cases ever brought in court under this wonderful North Carolina statute, which we have Professor Bill Reppy to thank for. It's an incredibly forward-thinking standing statute. So we're fortunate to have him here. Ladies and gentlemen, may I present Bruce Wagman.
Thanks. I took the Happy Cows case out of my presentation, but I guess I should talk about it at some point. There's a lot to talk about. Marilyn's asked me to give essentially 2 lectures that I give that usually run somewhere total time about 2.5 hours, and do it in an hour. So I've cut out a lot of slides. I've cut out all the slides, the really nice slides of animals, and unfortunately there's some graphic stuff in here, but that's the kind of thing I deal with on a daily basis. And the talk's going to be split up into 2 parts. The first part will be something we're calling the many species of animal law, which is all different ways to practice animal law, because it really is, it's a very, very big and broad practice right now. And then we'll talk specifically about animal hoarding in 3 cases in particular here in North Carolina. I definitely want to start by thanking Marilyn for inviting me, Marilyn also for helping out on one of the cases we're going to talk about, and mostly for that guy in the back, Professor Reppy, because he's really the leader. He's the reason I'm here. He's the frontiersman of this field of law. He's been doing it for a long time. He's somebody who a lot of us followed into the law because of what he did, and he's been seminal around the country. He's been seminal for me as a mentor, and also with respect to 19A, one of the most important laws in the country for hoarding and other animal abuse, which he's been working on the General Statutes Commission in North Carolina for some time. So it's really an honor for me to be here and talking to you. What we're going to talk about a lot, that's my dog. He said I had to put the picture in, but really, what we think about in America all the time is that kind of idyllic picture of animals. And whether it's a dog on a beach or a cow in a field or a chicken pecking in the dirt, that's what we think about. That's what we think about when we consider companion animals, when we consider who we eat, whose milk we drink, whose cheese we eat. But unfortunately, that's not the reality. And so today is about the reality versus what we think. This first part of the talk is just going to go over the various ways in which animal law is practiced. And in some ways, people think, well, you've got problems with animals and cruelty laws take care of them. Everybody says, well, there's laws against cruelty all over the country. Those laws will prevent any problems, therefore everything's okay. That's just simply not the case. For any number of reasons, the cruelty laws are, for the most part, not utilized by prosecutors around the country. They're not utilized because of under-enforcement, lack of knowledge about animal cruelty, lack of resources. Prosecutors have a choice between a rape or a murder or some animal cruelty. The animal cruelty gets put not even to the back of the desk, but off the desk. There's just no time. Prosecutors are overworked. And then in close to 35 states in the country, farm animals, research animals, and animals in entertainment are completely exempt from the cruelty laws. So you can do virtually anything you want to one of those animals, and they cannot be prosecuted. The violators cannot be prosecuted because they're actually not even violators, because the law is exempt. So that's one of the misconceptions we have in this country, is that the cruelty laws will take care of everything. Nevertheless, there's an awful lot of us, a lot of organizations, and a lot of lawyers out there fighting to do what we can to help animals. And here's an exemplar of a bunch of groups who are doing it. There's a couple law firms on there. Top left is Meyer, Glitzenstein, and Crystal, a law firm out of Washington, D.C., who's been doing this kind of litigation for about 20 years. They do about 40% animal law, 60% environmental law. They came from the environmental sector. They do some great work, usually in the federal sector, in federal courts, filing lawsuits either against the government or their biggest, current, most famous case is the ASPCA versus Ringling Brothers case, currently pending in the D.C. Circuit, which is challenging the cruelty to elephants in the circus. Many of these organizations are ones I have worked with or other animal lawyers often work with. Farm Sanctuary, who does what it sounds like. They have both a sanctuary for animals, but are very involved in both litigation and legislation involving protection of farm animals. I've got a bias. I'm a litigator, so when you go to a surgeon, he tells you to operate. When you come to a litigator, I tell you to litigate. But legislation is extremely important for protecting animals, and Farm Sanctuary has done an awful lot of important work there, as has the Humane Society of the United States. You see down there, they're involved both in litigation and legislation. There are particular groups who focus on particular interests. Mid-slide, you see the Chimpanzee Collaboratory, which focused almost solely on chimpanzees in entertainment, with some focus on chimpanzees in research. The Mountain Lion Foundation, pretty self-descriptive what they do. All big cats, but mountain lions around the country. The Animal Protection Institute has some focused programs, mainly exotic animals, either in entertainment or as companion animals, as some people might call them, pets. They're locked in cages, but they're exotic animals. And a whole lot of wildlife issues, steel jaw, leg hold traps, and that kind of thing. PCRM, the Physicians Committee for Responsible Medicine, is essentially promoting a vegan nation, if you will, or a vegan diet, and through that, hopefully protecting animals at the same time, because if everybody goes to a diet that doesn't include animals, then the animals who are being treated cruelly by the production of meat and dairy no longer are treated cruelly. So PCRM is headed by physicians, but basically run by lawyers who litigate and have programs in an effort to strike back at those who are exploiting animals. They also have a very big research component. So they've currently got a lawsuit against UC San Francisco trying to stop or at least curtail some of the most egregious violations of the Animal Welfare Act in the research facilities there. Who else have we got on there? PETA, of course, you've heard of them, I assume. People for the Ethical Treatment of Animals, if you hadn't. They're focused in Norfolk, Virginia, one of the most famous animal protection organizations because they're out there. They do campaigns that people pay attention to, that get a lot of flash, do a lot of billboards. They're either loved or hated by you and by people in every state around the country, but they do an awful lot of good work. Again, a lot of litigation, not as much legislation, and an awful lot of grassroots campaigns. PETA's probably responsible for the decision by Nike to drop Michael Vick. They're probably responsible for a lot of what happened to Michael Vick just because they were out there. Their campaigns are things where they're sending out posters and billboards to 30,000 protesters around the country on a Friday so that on Monday everybody hits the corporate headquarters of a given place and changes things. That's not law, but that is what's helping animals, and certainly there's always lawyers behind that. There's lawyers to decide whether the practices are illegal, whether there's defamation involved, and usually to defend the defamation lawsuits when they come up, whether or not there was defamation. IDA, bottom left there, in Defense of Animals, a group out of Mill Valley, California, responsible for a whole bunch of work over the years. One of their most famous campaigns is the Guardian campaign, where they have gone around the country and gotten a lot of cities and even one state, Rhode Island, I believe, to change the terminology in the laws from owner to guardian for companion animals. It doesn't change the law at all. It's a matter of semantics, with the notion being that when people start thinking of companion animals when people start thinking of owners as guardians and companion animals as wards, that there will be more interest in caring for them, and possibly down the road some litigation in which someone could come in and say the guardian is not taking care of the ward, therefore the court should intervene. So those are some of the groups. Morgenstein and Jubileer, by the way, down at the very bottom is the firm I was in before we merged with Schiff Harden. So now we're going to talk about some really exemplar cases, and they're only illustrative. There's been enough cases that I've done and others have done over just the 15 years that I've been involved that there's far too many, even if we had the whole 2 hours just to talk about cases. So I'm going to weave social justice ideas, animal cruelty ideas, and legal ideas into this talk so that you get an appreciation of why the lawyers are doing this or why the groups are doing this and what the legal bases are for these lawsuits. Probably one of the most important things that's implicit to me at this point and to lawyers working in the field but may not be to you is that there's no clear laws protecting animals in this country. The cruelty laws are the only ones, and like I said, number one, they're under enforced, and number two, to put the point on it, you can't sue for cruelty. The only entity that can sue for cruelty is the government. And so if the government's not willing to, outside of North Carolina, where you have 19A, it can't be done. And so there are no laws protecting animals. So what animal lawyers are doing are looking at the books, looking at laws that don't necessarily pertain to animals, and utilizing them to help animals. And so that's been the effort, and that's what I'm going to try to weave into these cases and explain. The first case I ever had as an animal lawyer was involving the Tule elk of Marin County, Point Reyes National Seashore. They live in a national seashore. However, when that national seashore was dedicated to the people of the United States, it was owned by ranchers. The ranchers were bought off. There was a taking under the Fifth Amendment. They were all paid for their land, but they were also given 99-year leases for $1 to continue to operate their ranches, dairy ranches and beef ranches, which are, to most people's thoughts, still using animals for commercial exploitation. Then comes the Tule elk. The Tule elk needed a place to go. They were suffering from a disease up in Northern California. I do bear the privilege of being the only animal lawyer who has a disease named after him, brucellosis. You may have heard of it. Just kidding. It is the disease, but it's not named after me. It's a hoof disease. And so the Tule elk were brought down to Point Reyes because there was some habitat there for them to live on and hopefully get healthy on. And they did fantastically. In fact, they did so fantastically that they needed more room. That more room needed to be the ranches that the ranchers were on. So my first lawsuit as a, 2-month lawyer was I was hired by IDA, who makes its best efforts to hire people who don't cost a lot of money, was to try to get all the ranchers in Marin County off of their land because some elk wanted to live there. I failed. It's a procedural morass as to what the contracts were between the ranchers and the government, and there was no real law, but it was just something that we felt was wrong. And it was a great lesson for my entire career, that you really need to figure out what law you have to use, and that sometimes the answer is there's just nothing we can do. Sometimes there's injustice, but there's no way to stop it. And with animals, that's the case, I don't want to say more often than not, but on a very random and often basis. So this young lawyer, actually I was beginning to litigate the case and try to save these animals when I got a call, an anonymous call from someone who suggested that if I continued, there might be troubles with my health and the health of my family. Call it a death threat. It was an anonymous death threat. I live in a rural area, in the same area where the Tule elk live. And deciding that I wanted to be an old animal lawyer, like Bill, someday, I decided to drop the case. So that was the end of it. Lots of companion animal cases. Lots of animal lawyers do companion animal work. I'd say maybe if you counted them up in terms of numbers, the majority of animal lawyers work on companion animal cases. Those are two of my companion animals, who also insisted on being in the slideshow. But the various cases are your dog bit my dog, or your dog bit my cat, or your dog bit me, or veterinary malpractice. Those are probably the three biggest ones. But in those cases come up, as you might imagine, pretty often. Dogs bite, cats bite, and veterinarians make mistakes. And so a big part of many people's practices are these kind of cases. I did a bunch of these as a youngster. I don't do that many anymore, but there's some very interesting and compelling issues. If you've been in the class with Marilyn, you know, but there's damages issues with respect to the valuation of animals and how much they're worth and how much a plaintiff gets when their animal is killed. Likewise, how much a plaintiff gets when there's an injury but not a death. Animal law may be one of those areas, unlike normal human torts, where it's better to have a dead animal than an injured animal, because it's really hard to get a jury to think that an injury to an animal is really worth much money other than the veterinary bills. So much of it comes down to, outside of this civil work, to try to figure out what animals are worth, the big cases, the big cruelty cases. And we'll talk more about hoarding, but there's two varieties of cruelty cases. One is cases in which a single person has done a single event to a single animal, and the other are the big hoarding cases. And this is a picture from a hoarding case. You see this dog has virtually no teeth left. Her teeth have rotted out of her mouth because she has been in a situation of neglect, a hoarding situation, for some long period of time, some chronic period of time. And these animals often lose teeth, they lose eyes. This is just very standard in most big hoarding cases. This is the kind of thing we face. So rather than having this could be a single dog in a single cruelty case, that's why I'm showing this slide, whose owner has done something horrendous to them to make them lose their eye, or what it's from is from one of our hoarding cases where the animal's eyes were literally burning out of their heads because of the environment in which they lived. Okay, another nice slide. Other companion animal cases that are coming up more and more frequently now, just in the 15 years since I've been practicing, I really see this, a boom here, is these custody cases. Custody cases, the sort of uninteresting ones are the divorcing couple. And I say uninteresting because it's two people fighting about who gets the dog, and there are some very interesting issues, and the best interest of the animal is the idea we're trying to get forward, but it's not always something that the courts are willing to do. But the even more interesting ones to me are not a divorcing couple, but an unmarried couple. I've had 4 or 5 of these a year. The call comes in, "Hi, my name's Jane. My roommate had a cat. She left 6 months ago to follow what used to be the Grateful Dead. Now it's Fish or Widespread Panic. But they're off somewhere for 6 months, a year, 2 years. Then they come back and they say, I want the cat back. In the meantime, I, Jane, have taken care of the cat. I've fallen in love with the cat. I've taken the cat through cancer surgery." And there's a custody battle there, obviously brewing. The law treats animals as property, so in the cold eyes of the law, the cat is whoever bought the cats. But animal lawyers are trying to push that envelope and say, no, these are sentient beings who not only have feelings, but internal consciousness, and they should be allowed to make a choice, if you could figure that out, or to determine who among these two individuals is the better parent or guardian for the animal. So those custody cases, I think, are pretty interesting. Shelter litigation is really exploding as well in the companion animal sector. More and more people are recognizing that some shelters are not doing a great job. Some shelters are doing a fantastic job, and by no means do I mean to derogate shelters in general or all shelters, but there are some shelters where some really bad stuff is going on. And more animal lawyers are approaching that. It affects large numbers of animals, and so large numbers of animals can be helped. In California, there's a specific law called the Hayden Act, which covers about 30 statutes and governs treatment in shelters, and also dictates that animals be adopted if at all possible, and that they be given kindly veterinary care. Believe it or not, the word kindly is in a statute. I never could figure that out. Most states have some kind of shelter litigation, and so more and more people are doing that. I had a case also in West Hollywood involving an ordinance. West Hollywood is to California what California is to the rest of the country. So it's weird even by California standards. Weird in a good way. But West Hollywood enacted an ordinance that outlawed non-therapeutic declawing of cats. Many people like to declaw their cats, and many people do it just so the furniture doesn't get ripped up or so they don't get ripped up. And West Hollywood decided that that was cruel and that they were going to outlaw that practice within West Hollywood. The California Veterinary Medical Association sued West Hollywood and said that they were interfering with the practice of veterinary medicine in California. A litigation ensued which lasted about 3 years, and ultimately the California Supreme Court agreed with the city of West Hollywood that they could regulate this practice, which they decided to be cruel, in their own community. Now, it's a little case in a little community, but certainly many other California communities were waiting to see what the decision was, and I think there will be other such ordinances. But for me, what's really important there is that the court agreed that local communities can determine what is cruel and what isn't. What we've learned over the years is that cruelty is a moving target. The same statutes have been on the books for 100 or 200 years, but what was cruel 50 years ago, or what wasn't cruel 50 years ago, is cruel today. There are judicial opinions that say, well, if you argued that this is cruel, then it would probably also be cruel to drown a bunch of kittens. That couldn't possibly be cruel. That's a judicial opinion from maybe 50 years ago. Today, obviously, that would be cruel, I think, to all of us, not only in this room, but most judges. And so cruelty is changing over time. And what that California Supreme Court decision said to me is that local communities can make that decision and that it is moving. It's something like the Supreme Court's definition of obscenity. I don't know, I can't define it, but I know what it is when I see it. And cruelty is changing over time. I think that's promising for us because as a society, more and more, we are becoming more humane and more concerned about what we're doing to our animals. The other really big area that I focus on and the organizations focus on more than the individual lawyers is factory farming. And this is what many people call impact litigation because it affects not just millions of animals, but industry in a very significant way, and indeed the consumers. And there's a whole bunch of litigation out there involving factory farming, and it ranges from cases that affect animals directly and impact animals directly, in other words, how they're treated on a daily basis, and cases that affect the consumer's perception of what's happening with respect to animals. And in that latter category, I'd put what I always call the unhappy cows case. Everybody calls it the happy cows case. I'll explain since I don't have the slides anymore. In California, there's a bunch of television and billboard and radio ads in which the pitch is that happy cows, that California is a wonderful place to have a cow and have a cow grow up and create milk and cheese because they live in these beautiful, pristine, green pastures and they've got lots of room to roam and all they do is eat grass all day and it's lots and lots of land. And then the pitch is happy cows come from California and I guess it's, so then you're supposed to buy the California milk and buy California dairy. And here in this room, I don't know, to me it always seemed sort of silly, like that wouldn't make me buy the dairy. But the fact is that they polled consumers. And this is an important fact for all of our factory farming litigation. Whether people around the country obviously eat meat, eat eggs, drink milk, eat cheese. Everybody's okay with that. Most people are okay with that. But they also, I think for the most part, and the polls show, want to think that the animals they are eating or whose products they're drinking were treated well prior to the time the product got to the table. That's almost, I think, a written assumption when you purchase the product. My adversaries say, no, everybody knows animals are treated cruelly these days. They don't expect that. But that doesn't seem to be the case. And it certainly wasn't the case with the unhappy cows ads because the pitch was, buy California dairy products because these cows are happy and that'll make you, the consumer, happy. And when consumers were polled by the group that was putting on these ads, they said, yes, that will make us buy the milk. Now, the fact is that California cows are the unhappiest cows in the nation. And the fact is that California is the largest dairy state in the nation. I always thought it was Wisconsin, but it's not. 95% of California cows will never see a blade of grass, will never walk in a field. They live on solid, hard dirt lots that are dirt in the summer and mud in the winter. They are packed in very, very tightly. Think about 1,000 of us in this room. That's where they live. They suffer from really bad diseases all the time. They die very early, and I could go on. But those were the undisputed facts in this litigation, okay, was that, and nobody ever denied that. And so PETA sued under a misrepresentation statute, a consumer misrepresentation statute, False Practices Act, which is, again, one of those laws that has nothing to do with animals, but that animal lawyers are using more and more. And they said this is a misrepresentation to the consumer. The end of the story is PETA lost, and but the only reason they lost was on a technicality, and that was that the California Milk Advisory Board, which is a government entity, could not be considered a person, which was the term in the statute, under Business and Professions Code 17200, the law they sued under. You look for whatever you can get in animal protection litigation because we lose a lot because we're trying to change the world. And the judge at the hearing on the demur, which is like a Federal Rule of Civil Procedure 12b6 motion, said, there's no question in my mind that these animals are suffering. There's no question in my mind that this is a misrepresentation. But I'm denying your complaint and dismissing your complaint because I cannot consider the California Milk Advisory Board a person under the statute. And that's the way we lose a lot of our cases. Again, if you've been in the class or if you haven't, standing is what it's all about. That's how the defendants prevent many of these issues from ever coming to the public eye or certainly to judicial scrutiny. They stop the plaintiffs at the door. So in the California Milk Advisory Board, the plaintiffs were stopped at the door. So the question becomes, let me just one more point on that. So that's the type of litigation which, even if we won in the California Milk Advisory Board case, nothing would have happened for the cows. The remedy would have been take the ads off television. They can continue to treat the cows that way. So there may be an indirect impact because the public learns about the way animals are treated and the public responds with its wallet and says, we're not going to buy your product anymore. But ultimately, at the end of the day, even in a completely successful case like that, all you get is a change in labeling or advertising. But there are a whole bunch of cases like that. There's a whole bunch of cases brought by a group called Compassion Over Killing out of Washington, D.C., and by the Humane Society against the term Humane Care Certified on egg cartons, which again gives the consumer the idea, Humane Care Certified, that sounds pretty good. I want those eggs. Those chickens were treated well. Well, those chickens were in the same bad conditions that all the other chickens were in. Their manufacturer just decided to stamp the box with that term. And in that litigation, they actually got the term taken off. But the treatment of the chickens didn't change. So back to the first type of impact litigation involving factory farming, and that is to try to change treatment for the animals. The Animal Legal Defense Fund out of Cotati, California, has had a couple of cases involving these cows here, these calves, and these pigs. And both were more or less the same legal notion. So I'll talk about the facts for a second. This calf is a dairy calf and is taken from her mom within 24 hours of birth. She gets one dose of mom's milk and then she's taken away. The kind of things we put in the complaint, which again are undisputed, is that for somewhere between a day and a week after having her calf being taken away, a mother calf cries. And the kind of thing we need to present to the courts is that these are sentient animals just like your dog and your cat. Judges understand dogs and cats, but they don't understand cows and pigs. They don't understand chimpanzees even as much. And so you need to turn these animals into animals that they understand, that they can have some sympathy for. Otherwise, they're just what's on their plate. So we put in that kind of sentiment, but the facts of the matter is that this calf is taken from mom, driven some 30 to 100 miles away to a place called the calf ranch. This is industry practice now, and stuck in a crate like this. Looks like what you know as a veal crate, but it's not quite as confining as a veal crate. Not sure if you can see, but there's a chain around his neck, or her neck, and she can't move. She can't move more than 6 inches back and forth, and she can't move more than 6 inches side to side. She stays there between 60 and 180 days. In the pig situation, this is also pretty much industry standard, although phasing out. This is what's called a gestation crate. You can see the size of the pig, you can see the size of the crate. They are, for their entire lives, pushed up against the sides, ends, and front of these gestation crates. I take it back, they're not pushed up for their entire lives. These are mothers, by the way. These are breeding sows. During the time they're in the gestation crate, they're gestating, they're pregnant. When they give birth, they're put into another crate called the farrowing crate, which is really no bigger, except it has more of an opening on the side so that the piglets can suckle her. They can't ever get near her except to her nipples and suckle her. She's then immediately impregnated and put back into this crate. That's her entire life. Now, we probably could argue that's cruel per se, but in California, there's a wonderful law called California Penal Code 597T, which says that if you confine an animal, any animal, you must give them adequate exercise area. We think we have no problem arguing that this is not adequate exercise area. Believe it or not, I got at least one letter from industry that said it was adequate exercise area because they can stand up and lay down. But we're ready to litigate that. On the litigation side, on the legislation side, there's an awful lot of good stuff going on for farm animals. The Humane Society of the United States, Farm Sanctuary were first behind the initiative in Florida, which actually became a constitutional amendment banning just what you're looking at now, gestation crates. It was a great job, a great political move. Why did they pick Florida? There's no gestation crates in Florida. I think there were 150. In other words, no big opposition. So it was something that they were able to get through. It wasn't easy, but it was a lot easier than if they went to Georgia or probably North Carolina. They subsequently went to Arizona, got a law enacted banning gestation crates and veal crates. There were no veal crates, but there were gestation crates. Those are banned. The big one on the table now is California. They've got enough voter signatures for a voter initiative which will be coming up in November, which would ban gestation crates, veal crates, and battery cages. Battery cages is really the big focus for a lot of people, and that's because of some numbers. The numbers are that 10 billion animals are killed in our country every year for food. 10 billion. My friend David Wolfson always says, as soon as you say that number, it leaves the room. Because can any of us conceive of what 10 billion anything is? I can't. 9 billion of those 10 billion are chickens. So that's why the focus. One of the things when practicing impact litigation for animals is an unfortunate sort of Sophie's choice that has to be made. Which case do we take? The organizations I work for are nonprofits on limited budgets. Even the biggest ones have limited budgets, and especially limited litigation budgets. And so you have to decide with every case, is this case worth our resources? We get hundreds of individual animal cruelty cases, but to expend the resources there when instead you could affect 9 billion chickens or even 10,000 pigs like we have in our cork pork case, obviously the decision needs to be made. Tough decision, but it needs to be made. So that's why the focus is on battery cages. It would change the world for chickens all over California, where there are sure a lot of them. There are, by the way, no veal crates in California, but that's on the ballot. Veal crates is probably the one that everybody sort of has the biggest knee-jerk reaction to because there was a very effective campaign back in the 80s that got rid of most veal crates around the country. Okay. A couple other farm animal cases that have come up. The Humane Society of the United States filed in San Francisco in federal court. One was challenging the Humane Methods of Slaughter Act and the question of whether poultry, chickens, the 9 billion, were actually affected by that law. Unfortunately, that case got knocked out, but another case, the 28-hour law, which is really the only other law in the country affecting farm animals. We've got the Humane Methods of Slaughter Act, which affects them in their last moments, and the 28-hour law, which says you can't transport an animal for more than 28 hours without giving them food and water and a rest. For years, the USDA had said that chickens, poultry, were not included in the 28-hour law, and additionally that trucks didn't count. So that's how all the animals are driven these days. But way back when they wrote the law, it was railroads. And so the USDA was insisting that only railroads applied. HSUS won there, and so trucks are now included in the 28-hour law. Mountain lions, beautiful animals that live in very few spots around our country. Yes, I've switched gears. We're talking about mountain lions, and they're not farm animals. They're sort of an icon for us of the American frontier. They're absolutely beautiful animals. They've been either hunted to extinction or habitated out of extinction all over the country and are in great danger. In South Dakota, 2 years ago, the Department of Fish and Game decided they were going to have a mountain lion hunt. And we had a trial there over the course of 3 days in which the experts on the other side admitted that the mountain lion hunt could possibly extinct the animals, wipe out the entire population. We had what we figured was a winner. The judge said, let the hunt go forward. One of the big explanations, the big justifications for the hunt was that nobody is going to catch a mountain lion. Number one, there's so few, and number two, nobody's out there looking for mountain lions. 28 hours after we lost the case, the first mother was killed. The law also said you can't kill a mother with a nursing baby. Only this mother had walked away to find food for her nursing baby, who showed up just 10 seconds after she was killed. So they hadn't broken the law because they didn't know there was a baby there, but this nursing mother, this baby had lost his mother and was then transported to a zoo. Chimpanzees and great apes are a big focus also. They're a big focus for many people for many reasons, I guess, but one of the big reasons is that they're so like us. That's a term from Jane Goodall, but many of you probably know that chimpanzees and great apes are our closest relatives. The chimpanzees share 98.4, some say 98.6, doesn't really matter, percent of the DNA that we do. They're just like us. They've got opposable thumbs. Actually, they have opposable thumbs on their feet, so they're ahead of us. The one thing they can't do is talk like we're doing, which may be a benefit, actually. But they do vocalize, they speak, they live in family groups. Their young stay with the moms for 3 to 4 years and nurse for 3 years. And so people have focused on them because of their connection. They focus on them also because they're seen as sort of a gateway species to protection of animals throughout the world. Because if we can get people thinking there's somebody other than us, something other than a human who deserves some special treatment, then we can sort of move down if you think that way. I think if you ask my dogs, they'd say up the evolutionary scale to the highest species, dogs. But whatever way, chimpanzees and great apes have been a focus. And it's also because they're used so much in our society. They're used, as you probably know, in research. They're used in entertainment. We see them all the time. And they're pets. And so there's many ways to focus on it. I got my first chimpanzee case 12 years ago with a chimpanzee named Mo, who was kept in a cage like this for his entire 30 years in a little town called West Covina, California, by some people who had a story about how they got him, which could not have been true. And they were seeking to exploit him. And we tried to enter as Mo's guardian ad litem. That's a guardian at law, and in a particular case, children get guardians ad litem when their parents are arguing over custody or when they're orphaned. And so the notion is because chimpanzees are so like human children, they should also be entitled to guardians ad litem. And that's another idea that's moving forward that people are trying again and again, and more courts are at least thinking about it. No court has yet granted guardianship in a contested case, although we have done it in a few uncontested cases. But the notion is that chimpanzees should be treated like us. Just quick chimpanzee facts. Chimpanzee adult, anytime after 3 or 4 years, have the intellectual capability of a 3 to 4 year old human. So whatever I tell you we're doing to chimpanzees, think about a 3 to 4 year old human sitting in a cage for 30 years, or the other things we do to them. And that's intellectual capability, okay? That's just thought. And certainly there are many humans in our society who we love and keep alive who don't even have that capability. Emotional capability, though, it's believed chimpanzees have the same as us. So a 20, 30-year-old chimpanzee feels just like you do. We may not be able to tell what they feel, but we think they feel the same way. They've got the exact same makeup. And in order to take a chimpanzee, the one thing chimpanzees have different from us is they're not habituated like we are. They wouldn't be sitting in these chairs. They're wild animals. You can never take the wild out of a chimpanzee. So the chimpanzees that you see doing this, there's only one way to get them to do this, and that's to beat them as youngsters. That's to, number one, take them away from their moms, who they would spend 3 to 4 years with, and then to beat them with sticks and locks and chains. And I'm not making this up, this is testimony. And all the experts will say there is no other way to train a chimpanzee. And I sort of apologize for ruining the next movie you see, but if you ever see a chimpanzee on television, if you see a chimpanzee in a movie, if you see a chimpanzee in an ad in a magazine, they have been beaten. They have been mistreated. You'll go on the website of the trainer and they'll say they use only affection training. Well, we've done investigations on several trainers. They don't do affection training. That there, you think that's a smile. That's a fear grimace. That's the smile we see in movies. We say, oh, look, he's so happy. He must love what he's doing. No, he's scared to death. He's scared to death because the trainer who's been training him his whole life is standing outside the cage. So he smiles. He smiles for the cameras and whoever else. This is the reality. That's the ugly stick at a particular California compound that was used daily to beat chimpanzees. Not to beat them when they did something wrong, just to beat them. So that when you beat them, they grow up in abject fear. And here's the kicker really, for 3 to 5 years, maybe 5 at the outset, you can get them to perform. After 5 years, no matter how much fear you've instilled in them, they become wild animals. They become unmanageable. A 5-year-old, 6-year-old male chimpanzee could take your head off with one blow. So they're no longer safe. So at that point, after the industry is done with them, they send them off to places like research, to places like this. This chimpanzee's been sitting in a cave, in a dungeon in a place called Chestatee, Tennessee, for years. There's a place called Primarily Primates in Texas that warehouses chimpanzees and primates that was recently part of a number of pieces of litigation. Animals sitting in complete misery with no enrichment. Chimpanzees need the same kind of enrichment and contact that we do. These chimpanzees are just left, or they're sent to circuses, or again, to research. That's not a chimpanzee, but that's the kind of thing that's done to chimpanzees. You may also know that chimpanzees were, at least in late 80s, 90s, the sort of considered the best subject for AIDS research because they can get the virus, but they don't get sick, so we can continue to study them. So there are hundreds, if not a few thousand chimpanzees out around the country who have the AIDS virus. Can't ever live with another chimpanzee again, but are stuck with that for life. So that's where they end up. And so the litigation has focused on trying to stop this from any number of ways. There have been cases against the USDA, United States Department of Agriculture, under the Animal Welfare Act to get better treatment for them, because there actually are laws that say they deserve good treatment in the labs. A case that I brought in California against a trainer, and I use the word very loosely, by the name of Sid Yost, resulted in the rescue of the chimpanzees he had and was abusing. We brought that case under the Endangered Species Act, under an argument that we could file a private right of action under the animal cruelty law, and under some of the consumer protection laws. So the animal cruelty cases do not work for chimpanzees. There's one other hook for chimpanzees, is that captive chimpanzees in America, largely because of the AIDS research, are actually exempt from virtually all protection. While chimpanzees in the wild are protected by the Endangered Species Act, these chimpanzees are not. Oh. Okay, we'll just go there. They're not protected at all. So there's virtually no laws. There's potentially the cruelty laws in each state, but if there's an exemption for entertainment, then this chimpanzee would not even be protected from that. Horses. We're going to move to horses now. Horses have become a big popular item, horse litigation in the last few years, specifically horse slaughter for human consumption. And I'm going to move through these pictures quickly because they're pretty graphic, but this is, and I'm just going to take it off because I think everybody's had enough bad pictures, but I'll explain horse slaughter for human consumption. For some reason, horses have become our heroes. They are a sign, like the mountain lion, even more, of the Great West. It's our heritage. There's a special law, the wild burros and wild roaming, I'll never get it right now. There's a special law for wild horses and burros that protects them and keeps them from being killed. But over the years, we have eliminated horse slaughter for human consumption, and remember and hear how conditioned that is. It's only for human consumption. But we have said in America we won't eat horses. And state after state has outlawed horse slaughter for human consumption, or at least sale of horses for human consumption. However, it's a big industry over in Europe. We eat cows, they eat horses. Some people eat dogs. People eat different animals everywhere. And that's a cultural issue. And the cultural issues are important to consider both here in America and abroad. But the Americans were certainly very willing to go after horse slaughter for human consumption, and there seemed to be a consensus among voters. So in Texas and New Mexico, In the last 3 years, the Humane Society of the United States has brought cases, I take that back, the Texas and New Mexico legislatures have enacted statutes which outlawed the slaughter of horses for human consumption. There were big slaughterhouses in Texas and New Mexico, and the horses were slaughtered there and shipped over to mainly Belgium, where they were sold in restaurants over there. And so became a very big issue. Willie Nelson and all sorts of famous cowboys got on board and helped the horses. And in both of those cases, the horse slaughter industry challenged the laws, and in both of those cases they lost. So as of, I think it was last April, I worked on the Illinois case. The last slaughterhouse for horses for human consumption was knocked out in America. So you can no longer kill them here. You can kill them in Canada, you can kill them in New Mexico, and you can kill horses here. You can slaughter them for dog food or for rendering. You just can't do it for human consumption. And to me, that's really, it's important to think about that it's a niche. It's a very small thing we've done. You can still kill horses. You just have to find a new reason to kill them. But nevertheless, it's a very meaningful thing to Americans to say we're going to take this animal out of the food chain. And like the gateway that chimpanzees are, horses might be a gateway as well. Because at some point, horses become cows. One of the great coups, I think, on a PR basis is that the Animal Legal Defense Fund now has Willie Nelson coming out after cows. I had a chance to meet Willie when he was on the horse issue, and the issue was cowboys are coming out to protect the horses. And I said, well, why don't you call yourself horse boys? You're cowboys. Why don't you help the cows? Well, in the most recent PR, the Animal Legal Defense Fund has Willie Nelson saying it's time for the cowboys to come out for the cows. So who knows? It's obviously a lot bigger industry, but it could be next. Why is there a dolphin on here? Swim with the Dolphins programs. This is one of the good pictures. This is how we think of dolphins swimming out there in the wild. We're also fascinated by them. They're extremely intelligent, among the most intelligent marine mammals. They're sort of like the chimpanzees of the ocean. And whether you're old enough to remember Flipper or there's some dolphin in your life now, you know that they're really fascinating. And wouldn't it be great to swim with a dolphin? Seems pretty benign. You get in a pool, you swim around with the dolphin, you hang on to their fin. Turns out that's not really good for dolphins. And I don't just mean it's not good. I mean, to be in a swim with the dolphin program is torture for a dolphin. They're on medication all the time so that they're calm enough for you to ride with them. And so one of the cases I had was an effort to stop a swim with the dolphin program in Reno, Nevada. Great place for people who are gambling, then go swim with the dolphins. Some of these cases, like I said, there's problems, but there's no answers. This is a picture of axis deer in Point Reyes National Seashore, and the fallow deer also. Two different kinds of deer that were non-native, that were introduced to Point Reyes National Seashore in California about 40 years ago, and they've been cohabiting with the native deer. The National Park Service decided, from a conservation biology perspective, that it was going to kill the 1,400 axis and fallow deer. It has gotten some extreme community sentiment and response, but actually split the people you might think. The Audubon Society and the Sierra Club, support the culling of the animals, while the Animal Legal Defense Fund, the Marine Humane Society, a group called Wild Care and Defense of Animals, are all against it. And so there's been a battle going on. The national park, the way to approach and attack these kind of federal programs is through a law called NEPA, the National Environmental Policy Act, to attack the process by which they are going to kill the animals. They knew that the opposition was there, the government did, and so they prepared a 375-page, I know because I read it, environmental impact statement, which satisfied all the requirements. This is a case, and I put this up, well, these deer live about, or used to live about 20 minutes from me, but it's a case I've been called about probably 6 or 8 times by enraged citizens and groups who say, can't you do anything? And I tell them every time, no. Unfortunately, we can't stop the killing because it's supported. And so that picture's there to explain how sometimes there's problems. Sort of an odd case, pet cemeteries. One reason I put it in here is a pet cemetery case, even animal law. What is animal law? And I'm not going to go into that now, but this I thought was a animal law case that I got. The plaintiff, my client, was a woman who had 7 animals buried at this pet cemetery. And one day she got a letter and said, you know, we never told you, but we don't actually own the land. We're digging all your animals up. Sorry. Come get them. or we'll move them for you. And so the case was really about the respect for the animals, and that was the issue we pushed. We ultimately, they dug up the animals before we finished the case, but we ultimately got a fantastic settlement, far exceeding what I expected, and I think it really was a push for the animals. Back to companion animals, one last issue on companion animals, which is how we deal with them in our society. It's not 9 or 10 billion, but 5 to 6 million dogs and cats are killed in this country every year in shelters. And that shelter issue, like we talked about, is a problem, but so is euthanasia. This is a dog being lowered into a gas chamber. Gas chamber killing, euthanasia of dogs and cats is actually illegal in 42 states. But in the state of Georgia, it's not. And despite the fact that it's not, and despite the fact that the state of Georgia Department of Agriculture is required to enforce that law, they were on a regular basis encouraging shelters to buy gas chambers and gas dogs and cats in complete violation of the law. We approached them and said, you guys, it's pretty clear. The law's been around since 1990. It says you can't do this. And they just completely blew us off. And they blew us off over a period of years. And this is obviously an example of, I think, an important issue. Euthanasia is an important issue. But again, it was the state of Georgia thinking they never said this to us, but they just thought they're just dogs and cats. Who's going to care? Who's going to even bother? Well, we bothered. PETA supported the litigation. We found the gentleman who had been the author and sponsor of the law in 1990 to be our plaintiff, and we sued the state of Georgia and won, and shut down the gas chambers in Georgia. And after we shut them down, while a preliminary injunction was in place, the Department of Agriculture told all its inspectors, from now on, when you go to inspect, don't look at the gas chambers. That way we can't be told that we're doing anything wrong. And we discovered this and again brought them to court. And we were told there's no way you're going to win this case. You're suing the state of Georgia. That's in a Georgia court, obviously. You're not going to get this. We won the preliminary injunction, and then we took them to court for contempt. And we were told, well, maybe the first time, but never happen again. But judges don't like it when state governments just blatantly violate the law. And so again, we got a contempt order. So as it stands now, the gas chambers are shut down. There are exemptions in some counties, but the gas chambers that were illegally operating are all shut down.
What is it about gas chambers in particular that makes it less humane than a lethal injection?
Sure. And we'll have a lot of questions afterwards, but I'll answer this one because it's pertinent to this. It's a very good question, and like I say, 42 states say gas chamber euthanization is okay, but the general sentiment is, and we had, our complaint is filled with horrendous allegations about animals who don't die, who come out extremely sick. One puppy who had to be gassed 3 times. Pregnant animals and injured animals should not be gassed under anybody's standards. Nevertheless, how do you know if an animal is pregnant or injured? That's because the method of death, obviously, is breathing, and if your lungs are not operating fully, you can't get the poison in, and so you suffer. There were no controls, so while you're supposed to limit it by species and you're supposed to limit it by number, the shelters were not doing that. There would be 20 animals, dogs and cats, stuffed into one of these hot chambers and suffering there for somewhere between, maybe at the most merciful, a minute, up to 20 minutes. Even at a minute, it's not the right way to go. I will say that the Humane Society of the United States and the American Veterinary Medical Association approve euthanasia by gassing, but only as the last means. And the preferred means is euthanasia by injection. First a sedation, then injection. And so that's what we were pushing for, and more importantly, that's what the law said. We fortunately did not have to answer that question in the litigation because the law said euthanasia by injection, but certainly we had a reason behind it, and that's why there's a push on now. There's actually a lawsuit in North Carolina regarding euthanasia as well, filed by Union County. Last exemplar case, and this is kangaroos. Kangaroos, we don't have kangaroos in America. Well, we do if we wear Adidas shoes, because Adidas shoes are made out of kangaroo. And that's nothing wrong with that. They're made out of kangaroo or they're made out of cow. But in California, there was a specific law, there's old California again, huh? That says you cannot import kangaroo skin into California. But Adidas had a very big operation in California. And the reason for the law was because the way in which kangaroos are killed and culled in Australia is rather graphic and unpleasant. And another case in which this case was brought by a group called Viva, International Voice for Animals, against Adidas. And this case was won also by Viva, but shortly after the win, the state legislature enacted a law, or actually repealed the law, prohibiting the introduction of kangaroo skins into California, obviously in direct response to this lawsuit. But for years it had been illegal. Okay, a couple just closing comments about being an animal lawyer. You need to have somebody to review your briefs, okay? Don't try to do it alone. It's dangerous. You need somebody looking everything over. You need somebody on the press at all times, okay? Reading the paper, telling you what's in there, on top of things. And finally, most important of all, you need a private investigator. You need somebody who can get into these facilities, into the farm animal facilities, into shelters that nobody will think shouldn't be there. And so make sure you get somebody like that. And no, that's not animal cruelty. She liked it, okay? Okay, part 2. We're going to talk about hoarding, and 2 or 3 cases in particular. Wow, we're right on time. That's great. I'll even take a drink. The 3 cases I'm going to talk about, I'm going to give you some of the facts first, and then we're going to talk about the law and look at some evidence that was in the cases. And the 2 main cases are this Conyers case from 2007 that Marilyn worked on extensively, and the ALDF versus Barbara and Robert Woodley case that started in 2005 with Professor Reppy. I'm just a channel through which all their good work comes. And the 3rd case, which was not a case under the North Carolina Statute 19A, but was a giant hoarding case, involved a facility called All Creatures Great and Small out in Hendersonville, North Carolina. And since I was involved in all 3 of those and many other hoarding cases in the last several years here, I thought I'd talk about those 3 from the fact pattern, because the fact patterns give you some variation on the different hoarding situations. And just so, usually people say, well, what's wrong with North Carolina? How come you have all those lawsuits here? And just so you guys don't think I'm picking on you, the fact is there's that wonderful law that we mentioned that Professor Reppy's been involved in that allows civil suits for animal cruelty. And it's my personal opinion, and I think that of many people, that animal hoarding is the #1 threat to companion animals in our society today, without question, just because it affects the largest number of animals at the greatest amount of time and injury. Hoarding is not limited to companion animals, okay? The primarily primates situation I mentioned to you was 700 animals, 500 of them primates, no dogs or cats. There was it was a sheep case here in North Carolina recently that Kelly Ferris worked on, where a guy had 90 sheep in his house, I think. They were on the first floor. He was on the second floor, so everything was okay. It might have only been 30. It was a lot of sheep. And I don't know, I never have more than 5. Yeah, I never have 5 in my living room at any one time. Seriously, this is the cat lady, you know, it's the kind of thing we laugh about at times. It's not funny. It's not funny because animals in these situations suffer more and for longer periods of time than in any other situation than the factory farming situation, where they suffer from birth to death. And so the facts. Mrs. Woodley, it was always Mrs. Woodley, but it really was Mr. and Mrs. Woodley, had a home in Sanford, North Carolina that had approximately 500 dogs on the property when we first found out about it in November of 2005. And we, being the Animal Legal Defense Fund, first found out about it actually a little bit earlier. I think Bill told us maybe in August. But prior to that, Mrs. Woodley had been investigated. There had even been an attempt at a criminal prosecution, and she'd skated. And for one reason or another. When we first found out about it and started investigating, there were 500 animals. 150 of them were in it's more like a 3-car garage, but even 3-car garage is a lot of dogs. They were piled, stacked 3 and 4 crates high, one on top of the other, without any real floor. So if you're anywhere below the top, you understand what's coming down. And they were never let out of there. I also mentioned that one of the heroes of the Woodley case is Pat Sanford right there, who was the person who brought it to me. And we had a call that got all this thing started. The And she had kennels in various buildings that were filled with dogs, and you'll see plenty of pictures from Woodley. And she also had a bunch of them in her house, about 30 to 40 in the living room, and another 20 in a trailer that she lived in as well. Mrs. Woodley had heart disease and so could barely take care of the animals. So there was one caretaker for 500 animals, and that was Mr. Woodley, who was 68 going on 83. He really, at trial, he slept through most of the trial. He had a lot of trouble walking. I'm just trying to paint the picture of one person trying to take care of 500 animals, or not take care of them. That's the Woodley case. It came to us because of the wonderful work of people like Pat Sanford and Bill Reppy, who reported it, and we got working with local rescue and investigated it and brought the lawsuit that we'll talk about. The Janie Conyers case came from right here in Raleigh, and that case came to us through a veterinarian, Kelly Ferris, who does an awful lot of hoarding work. She's a professor at NC State, and we worked with her on the Woodley case as well. Janie Conyers was a champion breeder. Anytime you think about those good breeders who win all those awards, that's what Janie Conyers was. Only she had in her home 106, they weren't all poodles, there was about 90 poodles, 9 birds, and a bunch of other little fake dogs, Maltese and picadors or whatever they are, in cages, who were never let out of the house and who were suffering badly. So she was much different than Mrs. Woodley. I will say Mrs. Woodley sold dogs. She sold dogs as much as she could. She claimed they were full breed dogs, but from the way everybody lived together in there, they clearly were probably not. Out of the Woodley case, we got something like 80 or 90 Boston Terriers, 40 Boxers, a bunch of mixed breeds, a bunch of Jack Russell Terriers, Pekingese, and Chihuahuas. Totaling 350 when we finally got them all out at the end. So the Conyers case came to us because Kelly Ferris had gotten a report. She went to the home to check it out. She went as an animal cruelty investigator under the North Carolina statutes and under 19A-46, entered the premises, saw the cruelty. It's a really interesting one for me. She called me on Thursday, a Thursday back in October, and she said, Bruce, I heard about this new case, and she calls me, I'd say every other week about a new case. I'm going to go check it out tomorrow, and I'll give you a call back. And usually she calls back the next day or maybe even a week later, and we talk about it. She calls back the next day at 2. She says, is it okay, Bruce? I took them all. I said, excuse me? She said, I took them all. Well, how many were there, Kelly? Well, there's 106 and 9 birds. You took them all today. Oh, okay. Let me find out if that was legal. Fortunately, it was because of Kelly's authority as an animal cruelty investigator. But that one happened extremely quickly, as opposed to Woodley, which happened extremely slowly. In Woodley, we filed a lawsuit. We had a trial. Again, we'll see some more about that. And we filed the lawsuit on December 24th of 2004, and it took us until October of 2007 to actually have ownership of the animals, although we had custody of them in 5 months after the trial. But it was a very protracted 5 months in which we knew the animals were suffering and couldn't stop it. Whereas in Conyers, they were ours like that. Changes the whole perspective of the lawsuit and the way you need to run the lawsuit. When the animals are in your possession, you're able to treat them and care for them and put them in foster homes. Really lets you sort of sit back, make sure you honor constitutional protections and due process protections, but otherwise take your time because the animals are in your control. Whereas with Woodley, every single day there were calls from our veterinarians who were monitoring the dogs, crying, saying they're suffering, they're dying, there's puppies dying, there's puppies infected or infested with beetles, who I've never seen on a dog before, eating the puppies. And nothing we could do because the court was pretty unwilling to act quickly for us in any of the Woodley case. So there's 2 completely different scenarios factually, if you will, on the outer edge, if you will. The inner edge, that is the hoarding, was the exact same, and we'll see the pictures of the suffering that was going on, that these animals were experiencing for years. And finally, all creatures great and small. And all creatures great and small is important because it's illustrative of something that's happening all over this country. And again, let me emphasize, hoarding happens in every state in this country. There are pockets that seem like they've got more puppy mills and more hoarders, but it's in every state, in every community, I'm convinced. It's just a matter of the numbers. All Creatures Great and Small calls itself a sanctuary. I don't know if their website's still up, but if you went on their website, you might think, well, I might send them some money. It looks like a good place. They adopt out these dogs. They take care of them. They're no-kill. They look fantastic. Well, I was involved with All Creatures for 3 years, and PETA was involved investigating them probably for much longer than that. It was somebody came up with a great term I wish I had, but it wasn't a no-kill shelter. It was a slow-kill shelter because the animals there suffered. They were in two general varieties. They either were large groups of large dogs in 10 by 10 kennels who were rarely let out. And because of that situation, because of the aggression in there, they all became nasty and vicious dogs, at least while they were in there. The good news is when we took them out one by one, they were okay dogs. But they lived in this horrible environment for years. And then the other ones were in the building at All Creatures Great and Small, which had more rats than dogs. And the dogs were kept in small cages, big dogs in small cages, which they could just barely fit in. And like the dogs in all these hoarding situations, they laid in their own feces, in their own urine, something dogs don't like to do. And the All Creatures folks, actually all of them, didn't get water regularly, didn't get clean water for sure, rarely got clean food. And at All Creatures Great and Small, well, at its peak, I think they had something like 700 or 800 animals. Without going into great detail, the state of North Carolina got involved really at the urging of PETA and the Animal Legal Defense Fund, and got the state involved in enforcing what was going on, or trying to enforce the Animal Welfare Act of North Carolina because of the treatment there. And ultimately, the good news is that All Creatures Great and Small is now closed, and in February, we settled the case, went in and adopted out the last 150 animals. And while we really thought, and this is often the situation, the sad but true situation with these hoarding cases, that many of these animals will have to be euthanized because of the way they've been treated, especially if they're large dogs. They may be unadoptable, aggressive, untrainable. We all heard about the Michael Vick dogs, but setting them aside, because they're 40, they got national attention, that's what happens in large hoarding situations. But with All Creatures Great and Small, when we took these dogs out of these packs, they were good dogs. And we had to euthanize very, very few. And all of them went to good homes. So, keep talking about hoarders, and I wanted to just set those facts, because now it's all going to hopefully fit in. This is my list of characteristics of animal hoarders, and there's six here, but 1, 4, and 5 are really, those are the absolutes, okay? They have more animals. I usually define hoarding with one sentence. It's people who have more animals than they can care for, and they don't realize that they're suffering, period. And then my students always ask me, well, how many is too many? And I say, well, it's more than 8, because that's how many I have. I've been told after 10 I might get reported, but I have 8. But the point is, obviously, I have 8 who, they don't just sleep on the couch, they have beds on the couch, okay? They all get different food every night. And if they're on the couch, I sit on the floor. But back to hoarders. They have more animals than they can properly care for. It might be 10. It's usually, judging them all, 40 to 80. There's a website and a group called the Hoarding Animals Research Consortium at Tufts University, and you can read a whole lot more about them. I don't agree with everything they have to say, but certainly we're in agreement on this. Number 4, like I said, the animals are always suffering. That's the sign of a hoarding situation. It's too many animals and they're suffering. And the hoarder says, there's nothing wrong with these animals. Mrs. Woodley and Ms. Conyers both said, I love my animals, I took care of them. Mrs. Woodley went so far as to say that all the diseases, all the lost eyes, all the lost teeth, everything that happened to 350 dogs were caused by me and Pat Sanford in the week after we took them out of our property. They were fine when they left. And that's the kind of thing they'll say. And they'll say it boldly. They'll say it so strongly that people will start to believe them because they've got that martyr notion to them. They're saving animals. These people are coming to take them away. They're going to kill them all. That'll be one of the things they say right away. And number 5 is the key for the trials, and we'll talk about that a little bit in a little bit. Oh, I was supposed to go just an hour. I was thinking 2 hours.
You're good.
Okay. Wow. Recidivism, number 5. They're almost guaranteed recidivists. They will repeat. They will do it again. They will do it again and again and again. They are akin to alcoholics or drug addicts. They're obsessive compulsives. They have The term "one is too many and 1,000 never enough" applies to hoarders, okay? They will repeat if they have the opportunity. And in North Carolina, you have this wonderful law. I was having such a good time, I was thinking I had an hour for each half, and I really only had a half an hour for each half.
No, we said
I'm good.
4:30.
Okay, we're good. We'll get there. Okay, so here's 19A. The key in 19A is those three terms at the top: physical pain, suffering, or death. Other cruelty statutes have a number of terms. That's what you have to prove in a 19A trial: physical pain, suffering, or death. Query, does physical apply to suffering or not? We pitch it both ways in the trials and in the cases. And again, it's a civil remedy, so you avoid the prosecutor, you avoid the beyond a reasonable doubt burden of proof, and the result is you can get a preliminary injunction which allows you to get all the animals taken away, and ultimately you can get a permanent injunction which allows ownership and possession to be transferred. This is radical stuff. Okay, you all took property in first year, right? You remember how important property is in America. This is taking someone's property away because they have abused their property. Could you take away my car if I decided to bash it in a few times? No. So this is a recognition by the legislature of North Carolina that animals mean something, that there's something different than property, that they're property plus, or they're a quasi-person. And that's so important. And that's what this statute allows to be done. And that's what's so amazing about it, that it's in a civil context. And it recognizes that if they are going to suffer again, if a court determines that, then you can take them away. So this is the kind of thing you see in hoarding situations. Horrible skin disease called alopecia. This is the Woodleys. These dogs are living in this box. The box is filled with feces and urine. They never leave the box. They don't go out for any reason. Mr. Woodley throws kibble in there, not even in a bowl, onto the feces-covered floor for them to eat every day. This one always works well with male judges. Those are testicles, and they are as red as you can get, and they're covered with ulcers. All of the animals in the Woodley case, and many in the Conyers cases, had what's called scalding. They're lying in urine and feces for months and months. Their skin is literally burned from the ammonia in those substances. Crucial at any trial in a 19A or any cruelty case is deposition and trial testimony of veterinarians. So there's Dr. Bartfield talking about a dog lying in urine and fecal-soaked newspaper because she was unable to get up. This particular dog couldn't actually not rise. She had a neurological deficit. She was lying there in something like 3 to 6 weeks of urine and feces. And Mrs. Woodley said there's nothing wrong with her. And she was in Mrs. Woodley's kitchen. Like I showed you before, dental disease is horrible. This dog has lost most of his teeth. 80% of the Woodley dogs had moderate to severe dental problems. Now, moderate problems are the kind that would have had you in the dentist a week ago or 2 weeks ago. So don't think moderate doesn't mean it's too bad. Severe means you'd be under anesthesia. That's what these dogs had. Their teeth were rotting out. Their gums were rotting out. They had fistulas going up into their nasal cavities from the infection. And most important, all of this stuff could be treated by just treating the dogs normally, by giving them what they deserve. Not by any kind of special procedure, not by spending a lot of money, what the defendants always cry, it's going to cost too much money to do this. It wouldn't have cost Mrs. Woodley any money. All she would have had to do was clean up after the dogs. And if you can't do that, you shouldn't have them. You need to establish the long-term chronic nature of this. Otherwise, a judge is not willing to give you the ultimate remedy under 19A, which is to hand over the dogs. He's only going to say, well, she needs to have less dogs, or better do better next time. They're not suffering that badly. And so it's very important to establish the severe suffering and for a long period of time. And we had testimony from Mrs. Woodley going back 20 years. Many of them were obviously emaciated. You saw all those dogs in those boxes together. Well, the stronger dogs get the food, the weaker dogs don't. This also happens to be Buddy. This was not, he was not alone. Buddy's jaw was broken at some point, not broken by some trauma, broken because it rotted out of his head from all that decay. And when it rotted out, his jaw broke, and then it set itself, without veterinary care, of course, because Mrs. Woodley hadn't seen a veterinarian in 5 years. And so his jaw was reset in a way that his tongue hung out of his mouth all the time. This is Buddy permanently. Dogs adapt. Buddy was a pretty happy dog once we got him out of there, but this is the kind of treatment that hoarders give to animals. You need details that demonstrate pain and suffering. And again, so here's Dr. Bartfield talking about the fistulas I was just mentioning and the horrible pain and suffering and the long-standing. She says, probably years of infection and teeth rotting out one by one. And as Dr. Hansen, who you'll see a little bit of, testified, that hurts just like it would you. That's what you've got to convince a judge. You've got to convince him that the tooth rotting out in this dog's head, one tooth, feels just the way it would in your mouth. And this dog lost all his teeth over years. That's Dee Dee. Dee Dee had both bad eyes and bad teeth. This is a Conyers dog, same kind of thing. And there's Dr. Bartfield again testifying. It was so incredibly painful that it should have been treated immediately. And again, you need to hammer this home to a judge. I'm convinced that unless you present the absolute most graphic and most long-standing pain and suffering to a judge, you're not going to get the ultimate remedy. He's going to give them another chance. And knowing what we know about recidivism, you have to shoot for that ultimate remedy, which is getting all the animals away. There's Dee Dee's eyes. Dee Dee's eyes, one eye was burning out of her head from pneumonia. The other one had severe glaucoma. I don't know if you know about glaucoma, but it's pressure in your eye. They had pressure in their eye 20 times the amount that a normal human would be running to a doctor for. And they'd been suffering with that for years. Extremely painful. This dog was from the Conyers case. His name was Lover. He had to be euthanized. He was completely covered in feces. His penis was matted to his skin with feces. He had no teeth in his head, and he could barely rise. Horrible infections in the mouths. Again, barren conditions. Absolutely no kind of enrichment, no enhancement. This dog is sort of doing a stereotypical behavior of looking into a corner. You have to get the hoarder to admit there's a problem, and they won't. So we had this picture. This is a picture of Ruby. Ruby's got an infection in her eye that runs down the side of her face here, all the way to here, filled with pus. And Mrs. Woodley said Ruby was fine. These are Mrs. Woodley's hands, saying Ruby is just fine. We were able to show the judge the veterinary testimony of what happened to Ruby, what kind of veterinary care she needed, and then Mrs. Woodley said she was fine. Then you need to bring home to the court just how animals feel, that they feel like us in some way. You need to turn that emotion into something a judge will understand. This is Bernie Hansen, an expert in pain and suffering in dogs and cats. He's made his career out of it, and he's a professor at NC State, published over 100 papers. He's the president of the pain, a national pain organization for animals. And so he described pain, and the judge listened. And what Bernie explained that any of us who have dogs know is everything is now, right? If you go away for 3 hours and you come back, your dog's woo-hoo-hoo. If you go away for 3 minutes and you come back, your dog's woo-hoo-hoo. It's all now. And that's great when it's that. But pain is all now. When a dog is in pain, it's forever. They don't think they'll ever get out of it. And these dogs have been living in that pain for years, literally. And so that kind of suffering is what it was important to bring home to the judge in the Woodley case. Bernie's last statement, they're living in an environment that gives them nothing to focus on but their pain. These dogs never left those kennels. They never left those boxes. They're warehoused, okay? And again, environment. We all know this to be true, and it's not really a subjective statement. It's really a factual statement. We raise dogs to be incorporated into our lives as companions, to love them and have them love us. That's what they're meant to do. That's how we got them here, and that's what we domesticated them for. So when they spend their lives in cages, they don't get to do that. Lives in cages on urine-soaked floors. This one's great in a way, because that floor is a linoleum floor worn away by the urine coming out of that cage. This, by the way, is the Woodley's living room. When we went in, that dog was there, and Mr. Woodley was sitting there watching television. The first thing that Dr. Bartfield got greeted by when she walked in was a dog peeing on her leg. Because, again, I want to emphasize, these dogs didn't leave the house. 35 dogs in a house. They didn't go out, okay? Whatever that means to you, when your dog goes out, they didn't go out. They went in, okay? And they didn't clean it up, the Woodleys. It was smeared. Again, the expert testimony is so important. It's the environment, again, is also what's important, because you can identify in any particular situation a number of dogs that are horrible. In the Woodley case, it was pretty high. In the Conyers case, to be honest, it wasn't that high. The basement dogs were terrible. The living room dogs were not that terrible. So you might expect a judge to say, okay, Animal Legal Defense Fund, you can have the basement dogs, but the upstairs dogs look okay. So you need to convince the judge that it's the environment of hoarding, that they can't stop what they're doing, the hoarder that is, that the environment is sick. Only if you convince them that the environment is sick will the judge say, okay, you can have them all, because they can't return. And we had testimony like that, like this, in all of the cases. So veterinarians who are experts on hoarding, you need to get an expert on hoarding and on pain and suffering to testify about this, to testify that this is unacceptable, that this environment will repeat itself. And here's sort of the crucial testimony on recidivism from Dr. Barfield. Nothing is going to change until they're removed from the premises. That's the end of it. And there's nobody that disputes that. The defendant will say, oh, I can do better, but there's no scientific evidence. And of course, in Woodley, when you have cases like, excuse me, like this, which is her kitchen, and you have scientific objective testimony from Dr. Ferris that the ammonia level in both Woodley's and Conyers' house were 20 to 40 times higher than is allowed by the USDA in large swine operations. And I'm talking about ammonia that our volunteers and veterinarians went in there, got sick every time they went in. It never got better. When I went into the Woodley's house, 5 months later, I got sick, even though there were a lot less dogs. So you need to convince the court that that ammonia level, that this kind of warehousing is unacceptable. That looks like a really cute picture, but you know what? Those dogs never left there. And that's the entire enclosure.
I have a question. Oh, sorry.
I'll be-
You're gonna take questions.
Yeah, I'll be done and then we'll take questions. The Woodleys also had these boxes, which I just always consider just the boxes of horror. Dogs lived in those boxes, okay? As you can see, there's no sides, there's no windows. And some of the boxes had nails in them. I think Mr. Woodley, because they bounced up and down, put nails in them, he'd take the nails off, throw some food in, and put the nails back on. That's where dogs lived. Or they lived in these kind of kennels. And here's Dr. Hansen in one of the best pieces of testimony that we got that wasn't even planned. He compared the life of a dog in a hoarding situation to a concentration camp, to Auschwitz. Now, I don't know if that would have gone over in a heavily Jewish population or from somebody else, but Bernie Hansen is an incredible witness, and he's got the history and experience to testify this kind of thing. And he said it's basically the same thing. And when he said that, you could hear a pin drop in the courtroom. So the end result is we won in both of these cases. In Woodley, we got this permanent injunction, which you can't read, but basically we got all 350 dogs turned over to us. The Woodleys appealed into North Carolina Court of Appeal. We won there. They appealed to the North Carolina Supreme Court, and we won there by them denying review. And so just a few months ago, we're actually in the process now of turning all the dogs from fosters to adopted dogs. The Conyers case, we came down very hard. We got the dogs initially, and they didn't fight it. And so we entered into a settlement agreement, which of course you can't read also, but basically says she's giving up all the dogs. She won't have any more dogs for 5 years. She won't engage in the business of breeding anymore. She's basically out of business, which is what you have to get. So the good news, few last pictures and we're okay. So after all that, we get to save these dogs. We get to take them for rides. Actually, it's one of the veterinarian's daughters in the wagon, but me carrying a dog. These dogs had never been held. It was not an easy thing, by the way, taking care of and rescuing 350 dogs. And while I was there for a week or two here and there, people like Pat and hundreds of volunteers were there every day taking care of these dogs who sometimes didn't want to be talked to. They had never had human hands on them. Some of them were angry, some of them were mad, some of them were vicious, and some of them just were in shells and unsocialized and needed to be taken out, but we did it. And so we gave them rides and we gave them houses. This guy built that house for that dog. There are some amazing people in this world, and an awful lot of them are in North Carolina. They got to do something they'd never done before, which is pee outside. I mean, how good must that have felt for Samson? They got something else they never had. They got names. See, this is Edgar right here. Edgar now lives in California, by the way. He has trained Joyce Tischler, who's the head of the Animal Legal Defense Fund, to be his human, and so she follows him around. Edgar has more clothes than I do at this point. They also get to meet new friends who they never met before. But most importantly, what their legacy is, what dogs want, what dogs need, what we want to give them, is they get love. and they get a family. And maybe they get to run on the beach. Thanks. Questions?
The difference, when you took the animals in the Conley and the other one, obviously she, the poodles, she released them to Dr. Ferris and signed over. So that was why you were immediately able to give the vet care and everything?
No, Dr. Ferris took them under 19A-46, which allows her to seize them and requires her to give her intention to sue to Ms. Conyers. So we then filed a lawsuit against Ms. Conyers, which included affidavits and all the pictures that we had collected. It was after the lawsuit was filed and prior to the first hearing that she settled. So she didn't turn them over until we filed the lawsuit.
But you were able to give them vet care right away?
Oh, yeah.
Because Dr. Ferris?
Because she took them under 19A-46. So 19A-46 says that if the animal cruelty investigator sees cruelty, they are entitled to seize the animals and provide them vet care and take them wherever they want.
Unlike the Sanford case where they had to wait.
Because we didn't have an animal cruelty investigator involved. In that case, it was this wonderful woman named Cindy Bristow who went in there and bought 4 dogs. She sort of kicked it off along with Pat and the other volunteers. They contacted us and sent us the pictures. So first we called their lawyer and said, we think there's a problem. He said, no, the dogs are fine there. So then we filed the lawsuit, but we didn't have the animal cruelty. So it wasn't under 19A-46, it was under 19A-1. That's the difference. 19A-46 is the way to go.
But having an animal
Cruelty investigator.
and
But
Dr.
the county has to have one, not all counties have them.
Okay. So it's by county, Dr. Ferris can only do it in a certain.
She can only do it in Wake County.
If you were giving advice to young lawyers who are not going to practice animal law as their primary specialty, would you advise them to try and do some pro bono work in the area, or just work those extra hours and donate the money to people who do it for a living?
Pro bono, or both, but anyway, yeah. If you go to a corporate firm, you can do both, but yeah, no, my advice to any animal lawyer, any young lawyer, maybe even more to lawyers who want to be animal lawyers, is to find out how to be a litigator first. And don't go out and open your shingle and say, I'm an animal lawyer. You need to know what you're doing, because, I was lucky enough, my progress, I didn't talk about that, but I worked in a civil litigation firm, and I've been doing only animal law for about 4.5, 5 years now, but for the first 10 years, I was a litigator. I did all sorts of products liability and employment stuff. I learned how to propound discovery, write complaints, fight with people over depositions. Those litigation skills are generic. Just like the things you learn in law school, they all apply to animal law. So I'd say definitely pro bono work, start out with small cases. But I think anybody who wants to practice animal law, you're doing a disservice to the animals if you just say, okay, I'm an animal lawyer, let's take on a big case. And you just got out of law school.
So is there space for people who don't practice litigation? For instance, I practice patent law. I don't go into court.
Right.
And so I wonder, when I hear these things, it seems like this is hardcore litigation that's being used here, and it almost seems like I don't have any skills to bring to the table.
No, I could have talked for 2 more hours. We could have gotten into your stuff. No, especially now with the bioengineering and the cloning stuff getting bigger and bigger, I'd say patent pro bono lawyers will be very useful and already are in animal law. You got to find the people who are doing it, probably the bigger organizations that are doing it, but absolutely you could be helpful. Yeah. That animal law just covers such a broad area. I didn't even cover it all. I focused sort of on the things I do and the things I know, because patent is as far as I can get in talking about patents. Yeah.
Okay.
Just to what extent do you deal with the recidivism issue in, say, the Conyers situation, where you negotiated a settlement through psychological counseling or something? This woman's going to be allowed to have dogs in 5 years.
Yeah, but she's 82, so.
But what if she was 42?
If she was 42, we would have pushed it much harder. We do encourage it. In the Woodley case, we also tried to broach the subject. The judge wasn't interested. He was fine, in the Woodley case, he was fine with the fact that these animals were treated cruelly, we should get them, she should not be allowed to have animals, but he wasn't going into this sort of California notion of this is a psychological illness.
So it's not treated like drug recidivism?
Not yet. It's not got a DSM-4 diagnosis yet. It's not listed yet. It looks exactly like it. I go to hoarding sessions and conferences on regular hoarding, and they give a little short shrift to animal hoarding, but they're really talking about bottle caps. So it's just not recognized. In Conyers, we did try to get that in the settlement agreement, and they rejected it. The ultimate is, and people often say that question, I knew as soon as you started what you were going to say, or, about jail time. My role or my goal, personal and professional, is to save the animals. So I don't care if they go to jail as long as they can't have animals. And I would like them to get help, but as long as I save the animals, I'm okay.
Is there similar, you're on the legal side of it, is the Psychiatric Association, for instance, interested in this issue at all, or is any quarter interested in it?
They're interested to some degree, yes. The hoarding associations that I've worked with, they are definitely interested. Yeah, you had your hand up early, and we'll get to you. Yeah.
You were discussing the threat of hoarding in general as being such a problem for animals. Do you differentiate between hoarding cases and puppy mills? Because it seems like there's, okay, so.
I don't. I mean, people say, oh, you mean puppy mills? And puppy mills are hoarding situations if there's too many animals and they're not taken care of them. It's a generic definition. I mean, whether we can talk about breeding in another sense, but if a puppy mill has hundreds of puppies who are being mistreated and neglected, they're hoarders. And they call themselves puppy mills just like All Creatures call themselves a sanctuary. It's a front. Yes, sir.
What is the psychology behind hoarding? I mean, you listed the characteristics. It's an addictive personality, basically?
It's an obsessive compulsive disorder, which looks a lot like addiction, because the thing that looks most like addiction is, and it's been proven only anecdotally, but it's proven again and again anecdotally, is if they have one animal, often still, but in the past 20 years, judges would say, you've got too many animals. Get rid of 90 of them. You only can have 10. 2 years later, they have 200. And it keeps happening like that. So it's the addiction, alcoholism analog is that notion I mentioned. One is too many and 1,000 never enough. An alcoholic, at least under most scientific understanding, can't go back to social drinking. A drug addict can't go back to social using. Unfortunately, and it really is unfortunate, these people do at their core, I believe, love animals, but they've gone past the point where they can, just like alcoholics love alcohol and drug addicts love drugs. They've just gone past the point.
One more, if I may. When Georgia shuts down gas chambers, how is that enforced? I mean, shutting down is not actual removal, because they still have them for feral animals,
Exactly.
I would assume.
You got to hope that people who are supposed to follow the law, the Department of Agriculture, who we sued, is supposed to go in and inspect the shelters twice a year, and there's a euthanasia checkoff. So we just got to trust they're going to do it. I mean, I'm with you. I'm not sure they will, but.
You mentioned that the only way to get the wild out of chimpanzees is to beat it out of them. Is that also the case for other circus animals?
Yeah, chimpanzees is my focus. I've done like 12 chimpanzee cases, but any exotic animal, yeah, tigers, lions, animals who are supposed to be in the wild. I couldn't tell you species by species, but all the monkeys, all the primates, all the big cats, for sure. That's how, there were big cats at the facility we investigated, and they got it worse than the chimpanzees. Yes?
So my question was sort of on the line of the puppy mill issue. If you showed the Woodley case and the Conyers case both had animals in cages and in sort of contained facilities. So is there less chance of being able to get a good judgment if all the animals are just running loose in the house, or does it matter?
I think the Woodley house was one of the best things we had going for us, because
They were loose in the house.
with 35 of them loose in the house, first of all, she refused to let us in until we got a police escort. And Dr. Bartfield went in there with this police escort, and there's this dog, the one I described, lying in her own feces and urine in front of Mrs. Woodley. Well, she actually was in a cage, I'm sorry, but the others were just running around, peeing and defecating on the floor.
And they're aware, I mean, the owners are aware, right, of the pee and poop everywhere.
Mr.
No?
Woodley was sitting there. He was watching television.
Well, yeah, but it sounds like he might have been in another land. I mean, how else could you not know? But
No, you're right. No, you're right. I'm sorry. They were completely aware. They didn't think it was a problem. That's what it is. They don't think it's a problem.
The 6 points you put up, and live in deplorable personal living conditions, kind of what we're talking about, are those 6 definite staples you have to have?
No. That's what I,
And what was the sixth
I
one?
did gloss over
Sixth
those.
one.
1, 4, and 5, or like that sentence of mine is what I say. They have too many animals who they can't take care of, and they don't realize they're suffering. That's it. 6 was Probably, just their age. The most common hoarders are middle-aged, single white women. So watch out in about 20, 30 years. High percentage are middle-aged to older women. But it's really, the recidivism is the reason that we have to work so hard at getting all the animals away. And the definition is just that you're not taking care of however many animals you have. It could be 3.
Is that 100% recidivism?
It's as close to 100 as you can get, as
But-
far as we know. We've never seen anybody, let's put it this way, I've never seen anybody who has been a hoarder and returned to, normal drinking.
Who's responsible for following up on them, though? Who's responsible?
Animal control should in any local community. Whether they will or not depends on animal control. Pat?
Could you talk just a moment about the bonding bill, which we didn't have back in the Sanford case, which is a real tool now?
Oh, yeah, well, now we have the power, and we used it in the Conyers case, of the defendant in these hoarding cases in North Carolina under 19A 70? 70, is required to pay for the funds spent by whoever takes the animals, whether it's the animal cruelty investigator or the plaintiff, like the Animal Legal Defense Fund. So that's extremely powerful, as Pat said, because in the Woodley case, although I still think we had it then, it wasn't actually in the statute, but I think there was room for the judge to give it. But now it's specific that it's a lien on the defendant if they're found liable and the animals are taken away. Also, under 19A 46 and 47, the animal cruelty investigator, the county, if the county shelter has the animals, can actually seek the money immediately, which is really how we coerced the Conley settlement so quickly. Because while 19A 70 doesn't provide for the funds to be paid until after judgment, 19A 47 requires for the funds to be paid immediately. So what we did in our first filing in the Conyers case was presented Ms. Conyers with a $56,000 bill. And she, according to 19A 46 and 47, she had to pay that immediately.
It got her attention.
Yeah, absolutely. But that's only if a county shelter is involved. Otherwise, you don't have anything till the judgment. Yes, sir.
How did she pay that?
Well, she didn't. She settled.
Yeah, got
Yeah,
it.
we gave up the $56,000 when she gave up the dog.
Also, the Viktor Frankl parallel is good. How do you, as an attorney, present the concept of pain? You've got a judge that hears all sorts of stories about all sorts of stuff all day long.
I present it through people like Bernie Hansen, because
Uh-huh.
he's a veterinarian.
Right.
I mean, judges listen to veterinarians. They listen to veterinarians more than they listen to human doctors, because there's so many human doctors testifying on both sides of every issue. But they had a veterinarian in the Woodley case, but she was so unbelievable. She actually had been Dr. Hansen's student, but she was so unbelievable that he just dismissed her testimony. But that's what I do. I mean, I'm not kidding. Bernie Hansen is the world's expert on pain and suffering in dogs. So if I had to do a case without him, I'd be worried. But there are other doctors, other veterinarians like him. So you get Bernie Hansen on there to say, I've written 100 papers. I've studied dogs for 5,000 hours. I can tell you that when a dog has a toothache, it feels just like yours, Judge. The judge was sitting there writing. The whole trial, he was sort of stone-faced looking ahead. When Bernie Hansen came, he was like this, looking at him, writing the whole time. He was paying attention. Great guy. Came up and, I don't know if he had Birkenstocks, but he was carrying a Whole Foods bag filled with all the depositions, just in case he had to refer to them. So, great witness, really mild-mannered, not pretentious at all, but he really, so that's how I tell a judge about pain. Not through me.
Right.
With the ammonia smell and the example, was that on testimony, or did you actually have testing done?
We had testing. Kelly Ferris, dog bless her, she came in with the actual capsule or test tubes that are used in USDA facilities, and we put the test tubes into evidence. I mean, you couldn't dispute that. It was numbers. It was actual numbers. It was 20 times higher than, and just think about it, okay? In large swine facilities, 10,000 pigs in a big operation, probably 90% of the workers are migrant workers who we know the federal government is very concerned about, so they're really concerned about the health issues. That's the highest possible level that is allowed. Woodley's house is 20 times higher than that. Yeah, Pat.
I say that if you went in for 15 minutes, your eyes would burn so much that it would be hard to blink and your throat was sore. and these animals are in there 24/7.
And remember, the other thing, another point that Kelly pointed out as a matter of science is where's the ammonia? It's on the ground. Where's the dogs? They're on the ground. So even we're up here and we're experiencing it. If you got down on the ground, it really, we actually tested it, going up like this. And up here, it's only like 1/10 of what it was down there. And the dogs are down there in it. Yes, sir.
When you see the living conditions that these people live in, it kind of reminds you of like those videos of like hard drug addicts, like never clean their houses. Right. Do they have like substance abuse problems? Or are they just emotionally?
There are some with substance abuse problems, but I think it's more emotional. The Woodleys showed no sign of substance abuse, but I went quickly over their kitchen. There was a mirror in the living room that was completely covered with about a 1/4 inch thick of fly feces. Excuse me. So it was so thick with brown that you couldn't see the mirror. The kitchen was piled up. There were garbage cans filled with garbage, and they wouldn't empty it. They'd get another garbage can. And so there was garbage cans everywhere, pots and pans in the sink. And the first day that Dr. Barfield went in there, she was making a sandwich right there in the kitchen. Yes.
How'd you get this law passed in North Carolina, and what's the status in any other states in the country or the outlook for it?
Well, I don't think anybody's around who remembers. Well, maybe it's 1969 it was adopted. Maybe Pat can fill us in. Bill Reppy's been involved on the General Statutes Commission with all the modifications. Actually, I take that back. I contacted the guy. We did get in touch with him. The sponsor and author of the bill, he was contacted by a woman from the Humane Society, maybe Wake County Animal Control, when he was on the legislature. And the idea was, a great idea, way ahead of its time. And this guy put the bill forward and got it passed. I don't remember his name, but we actually were considering using him as a witness.
Yeah, it was actually the North Carolina Humane Federation, and what was happening in North Carolina, and to some extent it's still happening, is that animal control was not doing investigations, and Humane Society members were not allowed to. So this bill was passed for Humane Society people. And commissioners now can appoint Humane Society people to be humane investigators. They can't be paid by the county. Bill may have gotten that change. So animal control officers who are becoming more trained now can also use it.
I think the initial idea was actually for the Humane Societies, but the law clearly says any person. That was one of the challenges on appeal as to whether a California corporation could sue in North Carolina. It had no, if you're familiar with Article 3 standing or standing in general, had no injury really. What was the Animal Legal Defense Fund's injury for Mrs. Woodley in Sanford, North Carolina? But the fact is that under North Carolina law, the North Carolina legislature can decide whoever it wants has standing under any statute, and that's exactly what it did.
So is it pushing forward anywhere else, or is there any hope that
I'm sorry. So last year in California, we tried and we got as far as somebody considering to be a sponsor, and then it died. Legislation's definitely not my thing, but I was involved in this. And so in California, Illinois, and maybe a couple other states, we're attempting it. I mean, there's been an incredible amount of successful 19A litigation here. And what I was talking to Bill about it, I'll make the pitch here. I think some animal law student should write the law review article, and Bill will give you all the information about all the successful 19A cases that have gone down. So we can take that law review article and bring it around to the other states. I mean, this I didn't even talk about this, but the reason this law is so valuable, other than getting away from the burden of proof and getting away from the prosecutors, is it takes the burden off local communities. The problem with hoarding situations is not just the hoarders, it's that local communities cannot possibly take on the taxing burden of 300 animals. Where is any community, even Wake County, going to put 300 animals? They've got no place to put it. So without big national organizations willing to put their resources into it, their legal knowledge, and the shelter knowledge, it just doesn't happen. So an eye is turned from situations like the Woodleys. They knew about the Woodleys in Sanford for 20 years, but they didn't know what they could possibly do with these dogs. So ALDF came in and said, we'll take care of them. That's what makes 19A so valuable. And that's what we want to tell legislatures around the country. This will take the burden off of the state. It takes all the money, the burden goes on to these organizations who are very willing to do it. Yes, sir.
Is there a citizen's remedy for an abused or neglected animal in North Carolina?
Well, you could.
In terms of seizure?
You mean for, no, well, 19A.
Okay.
I'm not, you
So-
can, if I'm abusing a dog,
Uh-huh.
my dog,
Right.
You can sue me under 19A and get that dog
I
taken away.
can sue, but I can't seize, right?
You can.
I can't
Well-
take the animal from.
Oh, I see. Well, you can sue and seek a preliminary injunction, which is what we did in Woodley, and the judge could give you the animal that day, first day in the court.
Okay.
You follow me?
Yeah, also one more. What's with the USDA? I mean, I was one of the people writing every time they got rid of horse slaughter, the USDA came back and said, well, we'll do it this way. Or, no, we're going to ignore that, and we're going to ignore the legislature, in fact. We're going to ignore Congress. Or what's up with that? I mean, I mean, really?
That's another lecture. Actually, you're having somebody talk about the AWA only, I think, from the other side.
Yeah.
But, yeah, well, like I said, that's a long story, but you're right. Every time the Wild Horse and Burros Act was
Well,
amended, they tried
and
to.
I think what probably did them in the end is they peed off Congress. I mean, they went around Congress on it, and Congress doesn't like that at all.
Well,
Right?
there's
I mean,
some,
that had to be a factor in that.
and some strong legislative work from people like Nancy Perry at the Humane Society of the United States and Animal Protection Institute and Animal Welfare Institute, really lobbying.
Yeah.
They had everybody calling their congressman.
Yes, Jay, you raised your hand a while ago.
Yeah, I just had a question, going back to the hoarding stuff. Just practically speaking, when we're looking through like Kelly Ferris's directs and things like that, when you're trying to get this stuff in as admissible evidence, I mean, certainly she can testify as an expert as to what it looks like. But I mean, you're kind of stuck in the middle in between a psychological condition and a physical condition that's going on with the animals. Have you guys had any problems as far as admissibility with her testifying to psychological state for a hoarder?
She can, you need somebody like Dr. Hansen or Dr. Ferris who can lay the foundation that they have studied and understand the psychological state of dogs. They are the experts.
No, I don't mean the psychological state of dogs. I mean the psychological state of
the hoarder.
in order to prevent them.
That's almost easier. You can put that in through a veterinarian or a psychiatrist. We considered a psychiatrist expert in the Woodley case, but decided we didn't need that. But certainly, to make a sort of, I mean, it's tough to have them make a diagnosis, but they can talk about the symptoms of the problem and talk about hoarding. So I don't think that would be too much trouble to talk about. No, Dr. Ferris and Dr. Lyerly and Dr. Henson all talked about that. Now, the Woodley judge let almost everything in, but I don't think that's a big admissibility problem if you are saying, based on what other hoarders do and based on our study of hoarding, these are the symptoms of a hoarder, and she fits them perfectly. I mean, that's the way you hook it up. You just say, the reason we're saying that the animals have to be taken away is because she is a hoarder. The reason she is a hoarder is because she has these issues. So you don't have to say she's got a psychological problem as long as you describe the symptomatology and the conduct.
So then when you do that, do you find yourself, I mean, obviously your most important side is getting the dogs out of there, getting the animals out of there in a safe place. Does that tend to, if you convince a court or convince a judge that she is a hoarder, does that tend to, I guess, lessen her responsibility for what's happened because it might not be her fault, it's a psychological condition?
That's a great question, something I didn't address, but I will briefly, because in a broader answer to your question, but yes, it does, because these people are not people who have affirmatively gone up to a dog and hit him with a stick. They're much less culpable, as far as I'm concerned, than the people who train chimpanzees. Everything is passive, if you will. But neglect, when it causes cruelty, is cruelty. The bottom line is that cruelty is occurring. And the statute, for instance, I mean, anytime you can, because it's so rare for animal lawyers, point to the statute. It says physical pain, suffering, or death. It doesn't say knowing physical pain. It doesn't say she had to willingly do it. And there's some great North Carolina law, actually, which suggests that even that an omission, which causes torture, which is what we have here, constitutes sufficient conduct for a felony. So she is culpable. So it's sort of like the reckless disregard standard. That's what she's engaging in. So the fact that she's didn't affirmatively act, yes, it doesn't make her as bad as, like I say, the guy who beats his dog in one way. But the fact is that when we're talking about the suffering, we can deal with it because it's on such a large level. But you're absolutely right. It makes them look a little bit more palatable. In the Conyers case, it was this little old lady who had been taking care of dogs for all these years, and I believe she really loved them. Mrs. Woodley was really not a nice woman. I mean, she wasn't nice to us. She was always cursing at us and pointing her shotgun at us. So you just get not to like somebody after a while like that. But Mrs. Conyers just cried. And, you know, you have to feel bad for her. But the bottom line is you look at the dogs and you say, we got to take them away. So you're absolutely right. It is a problem because they're not evil. And the ones who run sanctuaries are even tougher. You know, we're the killers. We're going to come in and kill all their dogs. So it is a real problem in the hoarding cases. Yes?
You don't have to have a psychological determination, though, to ask the judge to put a ban on owning an animal under either 360 or 19A for
Oh, not at all.
5 years or permanently.
Right.
So you can go ahead and do this without any psychological evidence.
But I think also in North Carolina, unless you really have good expert testimony, it's going to be hard for a district court judge to be convinced that the nice 77-year-old lady might not be able to have 1 or 2 dogs unless you really, really thoroughly explore what this condition is.
Yeah, absolutely. I mean, these 2 cases, we never expected the results in either of them. The most frightening words I heard from the judge in the Woodley case was at one point he said, she's just got too many dogs. Well, that means less is okay. And that scared me because less would not have been okay. You know, I was all ready for the hit that would be, okay, she can have 50 because she's got this big property. It was a shock when he said that she had to have them all taken away. And Conyers the same thing. You know, we were worried. They weren't all in bad shape at all. It was the environment was bad, it was the neglect was bad, but the dogs upstairs were relatively healthy. I mean, the house was disgusting. That kind of thing really helps you in the hoarding cases. The health issues, the human health issues, even though they have nothing to do with cruelty, you pitch that to the judge. You tell them, I mean, in Woodley, not one of the dogs had a rabies vaccination in years. So you tell them the whole community is threatened. That doesn't have anything to do with 19A, but it makes the judge think, well, maybe this is a situation I need to take them away. So, and the health issues, houses filled with feces and urine. You know, judges don't like that. It has nothing to do, we could barely argue that it's not physical pain. It might be some kind of suffering for dogs to be living in their own urine and feces, but the dogs in Conyers upstairs were running around the house free, just that they went wherever they felt like it. But to a judge, that's pretty horrible. And again, a health issue. That has nothing to do with 19A. And we've thought about going under other statutes, but those other statutes would never net us the dogs.
It just left me.
Okay, we got one there. You can.
Yeah, I'll think about it.
How relevant with the animal cruelty statute is the issue of ownership, and how difficult is it for you as the plaintiff to establish that these dogs were owned by the defendant? I would imagine that a defense would be, these aren't mine, you know, these belong to so-and-so, I'm just keeping them here. Is it almost like a, I don't know, sort of a subjective test based on just the dogs being confined, or do you have to establish that the dogs are owned by the person?
Yeah, no, great question. We had this issue in Conyers. In Conyers, a bunch of the animals, well, she gave us a list of 50 of the dogs she said she didn't own. On the Friday before she gave us the list, she had called up a bunch of people and said, hey, I'd like to give you 10 dogs. And she put them down. And she thought her lawyer gave us this list and said, here, these dogs aren't hers, therefore they're not subject to the act. Well, number one, they're still subject to the act. And the act includes possession, not just ownership. Our concern from our side, of course, was that we'd get possession from Conyers and then the real owner would come in and say, give me the dog, which did happen in several instances. So yeah, it can be a problem. Every case is sort of slightly different. But in Conyers, we then had to go to war against 4 of the owners, who actually were valid owners. They had left the dogs at her house. And the way 19A reads is that unless the judge thinks cruelty will occur again, he shouldn't give us the dogs. So these owners, if they could prove they were innocent and didn't know what was going on, they could validly get the dogs back. Now, these dogs were all great breeding stock, and we wanted to stop that, obviously, almost as a political issue, you know. We wanted to spay and neuter them all. And these people wanted them back so they could make them more breeding stock. And so, you know, we had the cruelty. A couple of them, we knew that they knew what was going on. But if they were truly innocent, and there were some like that, we had no case against them. And we had to give them their dogs. We gave some dogs back to people who were truly innocent. But so it definitely can become an issue.
Have you ever had a hoarding case where somebody hoarded, say, cats and not dogs, and then were able to have
Switch
a
over?
dog or two without hoarding?
Oh, I've never seen that kind of case. We usually try to get the judgment to be any animals, but I've never seen that. But I'm sure, just like drug addicts switch drugs, I have heard of the contrary to what you're saying, is that they switch from dogs to cats.
We have a cat situation, and she's not with dogs. She has
Right.
2, and that's it. But we're afraid if all the cats go,
Then they'll start with dogs. Yeah.
Reese, thank you so
Thank
much
you.
for coming.
Yeah, thank you.